We particularly want to hear your vision.
Yes.
You should tell us who you are beyond what you have done.
Okay.
Yes.
Thank you, Honorable CJ and the commissioners. My name is Dalmas Omondi Ohungo. I am a husband and a father. I am a judge of the Environment and Land Code, having been appointed in the year 2016. My journey in the legal profession started 28 years ago in 1998 when I was admitted to the bar. Upon appointment as a judge, I was posted to Nakuru ELC, where I served until September 2021, mid-September, when I was transferred to Kakamega. I served there until mid-January last year, 2025, and then I was transferred to Nyamira County, where I currently serve. I'll just give you a snippet of my service and professional life so far, which I think will then answer to the question of what I present. I'll first begin with my professional capabilities and delivery. When I was serving in Nakuru, by the time I left Nakuru, the performance report of 2020-2021 reflected Nakuru as the overall best court in ELC. I don't need to go into details because of time. Subsequently, I went to Kakamega, and the performance reports will show that I have a very high merit productivity. This is reflects cases actually heard and determined by a judge on the basis of judgment and rulings written. Both the performance report of 2022, 2023, and 2023-2024. I will not also go into too much detail at this point. I had a very high, leading actually, case clearance and merit productivity. While I served in Kakamega, the Honorable Chief Justice appointed me the presiding judge of that station from March 2023, and I served in that capacity until I left. I think this is significant, one, because the Honorable CJ bestowed trust and faith in me, but above all, it's important to note that at that time, I was not necessarily the senior most judge in the station, but we worked very well. We were 5 judges in the station, I as an ELC judge, 3 High Court judges, and 1 ELRC judge. And we displayed collegiality with a very good working relationship. While working in Kakamega, I had the occasion to chair the ELC judges serving in the region, that is Bungoma, Busia, including Kakamega, and we were able to deliver on a very important project under my leadership, which is we developed a manual for self-represented litigants, a major milestone in access to justice and people-centered justice. The whole idea behind the manual is to help litigants who do not have the benefit of an advocate to know how to navigate the court processes. Also, one thing I would mention is that throughout my entire professional life, I have exhibited leadership qualities. I was from the onset, from 2001, I was a member of the Council of Mombasa Law Society, the oldest bar association in the country and the second largest bar, and remained in leadership in that bar association in various capacities, rising to become the vice chairman of that bar association. Again, in my life, I have both private and public life, professional life. I've exhibited the highest degree of discipline, professionalism, and integrity. In the 10 years that, about 10 years that I've been a judge, this commission has not had, not even once, to write to me asking me to respond on any allegation touching on integrity. That speaks to my qualities as an individual and as a judge. So these are the qualities, Honorable Commissioners, that I present before you, and if the Commissioners find merit in them, this is what I intend to take to the service in the Court of Appeal. Thank you.
Thank you. Commissioner Mwansa, for reading the next set of questions.
Thank you, Chief Justice. Judge, good afternoon again.
Good afternoon, Commissioner.
I want to cite for you a quote by a famous American poet,
Yes.
Maya Angelou.
Yes.
She says that courage
Yes.
is the most important of all the virtues, because without it, you can't practice any other virtue consistently.
Yes.
Now, one of the virtues that interests me is the virtue of judicial courage.
Yes.
And perhaps, Judge, can you explain to us what are the key aspects of this virtue?
Thank you very much, Commissioner. Courage is indeed an important virtue, and in the context of service as a judge or a judicial officer, the aspects of courage is that a judge has to be able to make the decisions that the case before him, the facts and the law and the reliefs sought call for, without looking into other issues on the side. So the ability to make the decision that the case before the judge calls for.
Okay, can you demonstrate to us one? I mean, you've made perhaps hundreds or so forth decisions.
Yes.
One that stands out in terms of an expression of judicial courage. So
yes. Thank you, Commissioner. Yes, I've made many decisions. I think one case in which perhaps I can cite is I sat on a bench. This was an expanded bench matter concerned the construction of the famous Itare Dam. And at that point there was I think a lot of clamor around the project, and we had the case with my colleagues in the bench. I was not alone, and we made a decision that spoke to the courage of the occasion and what was required of us, independently of the clamor around the particular case. I would cite that, Honorable Commissioner.
Thank you. Judge, perhaps I want to ask you about arbitration. You've had occasion, I'm sure, to read or interact with the Arbitration Act.
Yes.
And it's one of the live issues that ordinarily would land in your desk as a possible Court of Appeal judge.
Yes.
Now, you've read the decision in YouTube?
Yes, I have.
And what's your understanding about that decision?
You're referring to the Supreme Court
Yes,
one?
yes.
Yes. My understanding of that decision is that the Supreme Court elaborated on or highlighted and explained the very, very unique circumstances in which a party who has gone before the court challenging an arbitral award has gone before the High Court. When dissatisfied with the decision of the High Court, can then appeal to the Court of Appeal. And the Supreme Court really circumscribed those circumstances into, in fact...
And how does a party who's aggrieved by a decision
Yes.
of the High Court,
Yes.
in terms of enforcement or setting aside,
Yes.
travel to the Court of Appeal?
Well, they would travel ordinarily in the normal manner, file a notice of appeal
Yes.
within the requisite period,
Yes.
and thereafter file the record of appeal together with the memorandum
Yes.
within 60 days.
Yes. They do not have to seek for leave first before they file.
To go to the Court of Appeal
Yes.
in this respect,
Yes. From a reading of Newton.
I do not think that they need leave. I think they will meet the questions as to whether they fit within the parameters of Newton once they find themselves before the court.
Okay. Actually, what the Supreme Court said in that matter is that for purposes of sieving such matters,
Yes.
the Court of Appeal has to first test whether that is one is a case that can be admitted,
Yes.
and that has to be tested through leave.
Okay, then I would need to refresh. Yes.
Now, if you read section 35
Yes.
of the Arbitration Act, it provides for very limited, as I said, I mean, it provides for grounds upon which you can set aside an arbitral award.
Yes.
Number one, that the party to the arbitration was under some incapacity, that the agreement is not valid under the law which subjected the parties to it, that's the law of Kenya. The party making the application was not given a proper notice of appointment, and the arbitration deals with a dispute not contemplated by the contract.
Yes.
That gives that right of arbitration.
Yes.
Now, there's a very interesting statement that was made by the Supreme Court. I want to read it
Yes.
and then ask a question or two about it. Now, paragraph 76 of the Newton decision says as follows, that reading each of the above provisions,